above all powers, above all kings.
Good morning, ladies and gentlemen. I want to thank the leadership of Kingdom Equip for this opportunity. We couldn't have had this session at any better time than today. In fact, if in the Ghanaian Times issue of Friday, July 7th, 2023, appeared this story. I think the Ghana Pentecostal and Charismatic Council had a session with the Land Commission on the topic that we are taking a look at today. And the Greater Accra Regional Lands Officer, these are some of the issues that he raised, the issues, the rationale behind that interaction. And he said that they were engaging the churches and the religious leaders to equip them with the necessary knowledge and insights into the Land Act to enable them sensitize their congregations on their responsibilities. Then he also added that the churches and the Christian community need to be abreast with the issues relating to land acquisition in the country. Well, all of us, we've been to basic economics in secondary school. I think we learned about factors of production. And I think we were given 3 factors of production: capital, labor, entrepreneurship, and land. And out of the 4 factors of production, we realized that land is the only one which is fixed in nature. And land forms part of property. What is property anyway? I would take my definition from the Husband's Laws of England, volume 87, the 5th edition, published by LexisNexis. And it says that property is used to denote either ownership rights or the things which are the subjects of the ownership rights. And property could be, is normally divided into real and personal. We are interested in the real property. A real property denotes land and things that are attached to land, which, more or less have become parts of the land, or the land rights, which endure for life or are inheritable. So, real property as against personal property. And land is part of real property. You can inherit it. It is fixed. And, there are a whole lot of rights that go with it. There are different nuances. If you're talking about, there are 3 key issues that we may want to understand: possession, title, and ownership, which are very, very, very important when it comes to land acquisition. If we talk about possession, it means what the actual physical occupation of the land or the property. And it may also mean not only the actual possession itself, but then activities that will send a signal to everybody that the land, someone is in control, someone is in charge of that land, except any other person who is able to show or prove a better legal right to possession. So when a person wrongfully takes possession of a land belonging to another, that's why we say that the person is a squatter, or the person is in adverse possession, which is very, very, very important. Why is this so? Because if you have your land lying there, and somebody, a squatter, goes onto that land, and according to the section 10 of the limitation decree of 1972, the NRCD 54, you do not do anything about that for 12 years, then that person, the squatter, even though he's an adverse possessor, he is protected by law within the 12 years statutory period. So the possession, that's why normally you advise that once you get a land, put some sand there, fix your corner pillars, probably allow somebody to live on that land. All these are incidences of possession, so that at least anybody who comes to encroach on it, when you go to court, you may want to recite some of these issues as you having been in possession of the land. The other issue, or the other nuance that we may want to look at, is title. Title is different from possession. Title is the means by which a person establishes his right to the land. So title, enables somebody to, claim, or somebody who is the owner of the land to claim ownership. It may take the form of possession, as we have indicated, or it may be the form of a document, of a series of documents. It may be, the recitation of the oral tradition. At times when you take any indenture, is it that they may, especially in Accra and most parts where they don't have original documents covering those lands, unlike in UK, then you may have to tell the story. So you do your recitals. My great grandfather was a hunter. He went hunting. He shot at an animal. He was going to locate it. He found a river. There, blah 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 blah. All these are oral tradition indicating that the person has title. So you see that's why normally when you go to court, the first relief you are seeking in every land litigation, which is we have 11 land courts. All the 11 land courts, they can't handle the land cases. The Chief Justice created the general jurisdiction courts. They are handling land cases. Now the specialized courts, the labor courts, the financial courts, the family courts, they are all handling land cases. Then the third thing we may want to look at is the ownership itself. Ownership of land covers both possession of land and title. Ownership, the possession, you are in physical possession, and then you have title. So owner of a land is a person who can demonstrate that he and those through whom he claims the land, we call them, grantors, have, possessed the land for a long time, and there cannot be any reasonable probability that the land belongs to any other person. And then the owner of the land may, rely on his documents of title, or his mere possession, as we have looked at, or his, to prove his ownership. Let us quickly go through the land acquisition procedure for granting title to land in Ghana. Before applying for a land title, definitely you would have seen the land, you would have done your inspection, you would have tried to find out the interest that you are seeking. What interest in land are you seeking? Are you seeking for lease, freehold now, because it's been abolished more or less by the Constitution? So the interest that you are seeking, is it a lease? Is it a sub-lease? Is it an assignment? Is it a transfer? Is it a license? If you're talking about license, when you allow somebody to live on your land or put a kiosk on your land for some period, that's what we refer to as as a license. And Section 39, in fact, the new Land Act, Act 20 of 2020, Act 3036, I hope 1036. I hope everybody would, try and get a copy. If you go to Ghana Publishing, you get it. In that, the Section 39 deals with the subject matter of conveyancing. I won't go through that. What constitutes conveyance? Conveyance is the generic term that is used for all the drafting, every document that you prepare, covering land, whether it's a lease, whether it's a transfer, whether it's an assignment, that is what is, called a conveyance. And before you get to that point, you may want to have, a contract of sale. And by, basic law of contract could be oral or in written form. So we have an informal approach, and I think that's what most of us do. And that is what caused most of these, problems. You see the land, you go and meet the leaders or the head of the family and then all those things. And then you agree, they ask their surveyor to, go and show you the land. And in the past, the surveyors are here, so I'm not going to go there. In the past, somebody would even sit in his house and then, just, because he had been doing the demarcation, he would just, say that, okay, we've given plot number 1, 2, 3. So he does the site plan. And in the long run, you find out that the site plan of covering that land is in the sea. It's happened, it's happened several times. So that's the informal approach. Then the formal approach is where a prospective, purchaser enters into a written contract, what we call a contract of sale or sale and purchase, agreement. Then one important thing, we'll come back to it, is GRA. Now the GRA, for tax purposes, recently has been requesting for sale and purchase agreement, among other documents, under the Revenue Administration Act 2016, Act 915, and also Part 4 of the Income Tax Act 2015. You'll be there. So if you sell the Land Commission is supposed to furnish GRA with a list of applications for stamp duty and all those things. And so you are there, then they'll write to you that you have disposed of this land, so come and pay capital gain tax. That's what is going on right now. And then one of the document they ask for is your sale and purchase agreement. So when you go to Land Commission or whatever, what are you doing? We do what we call the deduction or investigation of title. Section 64 of the Act 2020 explains what a good title is. The law indicates a good title. So if you are buying a land, you do your deductions or your investigation, even though it's time consuming, it is expensive, but that is very, very important, because it is through the investigation of title or the deduction of title that you find out whether there are any liabilities on the land. So every seller of land or property should be able to prove that indeed he has a title to that land. And in fact, I will take the opportunity to read section 12. Now they said that if anybody who unlawfully exercises or purposes to exercise supervision or control of land development in the location and has no interest or extorts money, blah, 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 you commit an offense, liable to 5 years, not less than 5 years, or not less than 15 years imprisonment. It was in the old law. And then we are more abreast with the vigilantism and related offenses after the election here in this area. But if you look at the Act 999, the Act 999, the whole section 7 of that law, the whole section 7, deals with prohibition of activities of land guards. So it goes to reinforce the section 12 of the provision of section 12 of the Act 2:20.